How is child support assigned and calculated in New York State?
Child support in New York is generally done under what's called the Child Support Standards Act. So one starts with the calculation of gross income, subtracting out FICA for both parents, and that's Social Security Medicare tax. The law also subtracts out local income tax. So in New York State, that's only Yonkers and New York City local tax. After deduction of those three taxes, one arrives at adjusted gross income, and that is different from how the IRS defines it. So one cannot just look at that line on one's tax return and then say, oh, that must be what adjusted gross income is for child support purposes. After arriving at adjusted gross income, the statute as drafted then brings you on an Alice in Wonderland journey to arrive at the eventual child support amount. So once one has the adjusted gross income of both parents, you have to combine the adjusted gross income, and then that arrives at combined parental income. The child support law will then apply a specific percentage to those incomes. So that is 17% for one child, 25% for two children, 29% for three children, 32% for four children, and 35% or more for five or more children. Once one has that figure, then one has to determine the pro rata or ratio between the two parents' incomes. So if the incomes are roughly equal, then the ratio would be 50%, 50%. If one parent earns more than the other, then the ratio could be whatever it is, 55 to 45 or 60 to 40, something along those lines. Once one has the ratio, then you apply the ratio to the result of the aforementioned calculations to then determine what each parent would otherwise owe in basic child support. However, under New York state law, it is only the non-custodial parent that actually pays child support. So after going through that long, convoluted calculation, one then determines what the presumptive amount is that the non-custodial parent pays. Now, that doesn't end the Alice in Wonderland journey, because what you have arrived at is the presumptive amount for combined parental income up to the current statutory cap of $163,000 in combined parental income. And that current cap is as of 2022. It does change once every 2 years. So one just has to either consult with an attorney or take a look at the court's website to see what the new update is on combined parental income. So once one has the calculations of combined parental income up to 163, that is the presumptive amount. The court can deviate from the presumptive amount even for the calculation up to 163, but then the statute goes off the rails and doesn't give clear guidance to anyone, the courts, the lawyers, or the parties, as to what happens if the parties' incomes exceed $163,000. It literally just leaves it in the discretion of the individual judge or support magistrate to determine what to do if combined parental income exceeds $163,000. So there's a variety of ways that are mostly governed by case law at that point for the court to determine what amount, if any, to assess to the non-custodial parent for combined parental income that exceeds $163,000. Sometimes they just stick at the cap of $163,000. In other words, they do not order any child support beyond that amount. Sometimes they go and raise that cap to, let's say, 200 or 250 or 300 or 350 or 400 in combined parental income. It varies with the case, and it varies dependent on a host of factors. Principal among them, though not exclusive, is the needs of the child, as demonstrated by the custodial parent. So, if it's the custodial parent that wants more and more support, they better come into the case being prepared to justify the child support amount through receipts and invoices documenting expenses for the child. But that, in a nutshell, is how one arrives at basic child support.